Welcome, folks. My name's Craig McDermott. I'm a Douglas County judge. Been on the bench coming up on about 19 years, practiced law for 22 years before that. You can do the math for all of you young folks out there. I suppose that seems old. I'm going to try to go through this as though you're all new. There's a lot of experienced, well-respected lawyers here, but I'm doing this for the people who are new. So this will be like preaching to the choir for all of you experienced attorneys. A little bit of redundancy too with regard to the outline that Dave provided to everybody before today's event. With county court, there are three divisions. I'll start with the civil division, civil small claims division. And I want to point out there are 12 of us county judges. We have a very large docket. We are extremely busy. If anybody's going to have contact with the court system, it's most likely the county court. Cases move relatively quickly, a lot more quickly than they would in district court, and of course a lot more quickly than they would in the appellate court. With regard to the civil small claims cases, as most of you know, the civil small claims division is just right down at the bottom of the escalator here off to the right. So are the civil courtrooms. We do some things over in the Hall of Justice with regard to our hearings. The last time I looked, the jurisdictional amount was $57,000 for civil filings, $3,900 for small claims filings. We have a rotation among judges. We rotate in threes. So I rotate with Judge Marcuso and Judge Forsberg. So 3 times a year we're over here in the civil division handling cases in court. 20 in that courtroom is eviction cases, restitutions, garnishment liability, debtors exams, replevins, things along those lines. And we do that 3 times a year. Each judge rotates in sections of 3. So that's what happens in courtroom 20 with regard to the filings that come through the clerk's office. Now, if the case gets to a point of being contested, they get assigned to each of the judges. We set it down for a pretrial and then ultimately a trial. And each judge has their own pretrial date. We have our own trial month. Again, it'll be 3 times a year. So for me, it's March, it's July, and it's November. So my pretrial dates are the month before that. So we try to get things moving pretty quickly. I want to point out one thing, and I'm not going to give a seminar on this today, but most of you, or some of you, are at least familiar with the expedited case progression that we have now with regard to civil matters. That would be under Rule 6, 2201, and the following rules under the Supreme Court rules. That's Article 22 under Section 6. The statutory section related to that would be 252741 to 252749. Take a look at that when you have a chance. You can have expedited cases. I have only had 1 or 2 of them, so I'll be honest with you. I'm not an expert at it. I don't think any of us are because it hasn't been used very much at this point. But you can use it, and we think the individuals that might want to use it the most are those individuals who have small personal injury actions because they'll move a lot more quickly. Now, there's a lot of onus on the parties involved to make sure they follow the rules and the requirements of the expedited statutes and rules, but it makes things much easier when you get to the final hearing date. A lot of times the cases just simply go away. Maybe that's why I haven't seen a lot of them. I've only encountered it twice. So, small claims actions, as you know, lawyers are not allowed. Those are heard down in courtroom 24. The litigants are involved. Lawyers can get involved once a judgment's entered, or if the case is removed to the regular docket for trial. Lawyers can come in and remove the case, I think, 2 days before trial time. So that's when lawyers can get involved. I don't want to get stuck on all the civil matters. I'm going to jump to criminal proceedings. As you know, our criminal traffic division is located in the 2nd floor of the Hall of Justice. All the windows over there on the east side of the building. We handle in county court misdemeanors up to 1 year in jail, up to $1,000 in the way of a fine, or both of those possibilities. And anything short of that, we handle infractions. We do handle class 4. Well, actually, we handle all felonies, but we handle class 4 felonies to a certain extent. We are the initial hearing judges on felonies. until they get to the preliminary hearing stage. They're either bound over before that, or they're bound over at preliminary hearing to the district court. So we do handle the felonies. So I always like to say that we handle everything from speeding tickets up to homicides, but we aren't the final fact finder on the felony matters. There's a little push for us to start hearing the class 4 felonies. We can, but we're not doing that yet. We have an agreement with our district court, right, Tressa, that they are continuing to handle those. So we are not really handling those as of yet. If you want to get on the appointment list, you can contact our administrator's office and get on the appointment list for felony cases. I believe it's $65 an hour for the hourly rate on that. I think that's in court and out of court. Is that right? I think it's the same. Mm-hmm. So it's $65 an hour. It used to be $50. It was just raised within the last year or so. I think it's been about a year that it went up to $65. So you can get on the appointment list if you want to do criminal defense cases. So just make sure you contact our administrator's office. All of our criminal courts, again, are over in the Hall of Justice on the second floor. Courtrooms 26, 27, 28, and 29. 26 and 27 are our trial courtrooms. 26 are the traffic trials. 27 are the criminal trials. 28 are traffic arraignments. 29 are the criminal arraignments. We also do preliminary hearings in courtroom 625 up on the 6th floor in the Hall of Justice, and that's every morning. So you can check with the administrator's office or even at the windows for how our calendar shakes out. Like I said, I'm sure most of you are familiar with how that all works out. Jumping to probate. That's, of course, on the 3rd floor of the Hall of Justice. On the west side, we handle cases that fall into the multi-million-dollar category. We've all handled cases like that. We handle guardianships, conservatorships, estates, adoptions. And I'm going to talk about the scheduling. There's a little frustration, I'm looking at Ms. Wagner right now, with regard to how quickly we get things scheduled. Just a point of order. Each of us only gets 2 probate days per month. Because of the rollover, there's about 3 or 4 times a year we only get 1 probate day per month. So most of us try to find extra dates and times to squeeze our cases in. I'll do that twice a month. I squeeze them in with my civil motions, which are on the 2nd and 4th Thursday of every month. I try to squeeze cases in. I will also find other dates and times. I'll even squeeze them in at the end of my criminal hearings if I can, because we have to meet certain deadlines. For example, adoptions, we have to hear those within 60 days. So I try to get those in. I squeezed one in yesterday just so we could meet the statutory time limit. So we try to accommodate if we can. And again, each of us judges is a little bit different. Some judges are easy to get to, some judges aren't. It depends on how you go about trying to get to us. Send emails. Contact the administrator's office, contact our bailiffs, contact our secretaries. It's easy to do that by just Googling our name on the internet or contacting the administrator's office. We'll try to do what we can to accommodate hearings. It's not always perfect, but we do. Couple of do's and don'ts. This is what Dave really wants us to talk about. Just remember that we don't have law clerks at the county level. We aren't as spoiled as the district court judges. We don't have law clerks. We do a lot of the research ourselves. So we would ask if you have some sticky issues to please come prepared with a brief or a memorandum or a copy of the statute or a copy of the case law, or even email them to us in advance, just so we have an idea of what your argument is going to be. Frequently, the arguments are attached to the motion itself or the application or filing that's made. That's great, but many times the other side hasn't had a chance to respond. We'd ask that you come prepared so that we are at least equipped to make a decision, and if we take it under advisement, we'll let you know what the decision is. If you have a contested hearing, we ask that you have your exhibits prepared and marked beforehand, because if we have to stop and mark everything, sometimes we'll have 30 or 40 exhibits. It really slows everything down. So if you could have them mark in advance, and we have stickers that we like to use. If you want copies of the stickers or printouts of the stickers, come and talk to the bailiff beforehand, and she'll give them to you. And you can fill them out and have them ready to go at the time of the hearing. It makes it much easier. So specific dues. Number 1, be on time and be in person. We get requests still. COVID spoiled everybody. We still get requests for phone hearings, Zoom, WebEx, and those are wonderful if they're absolutely necessary. But I've had people contact me who are here in town saying, I want to appear by WebEx because my client said it's okay. And I said, well, your office is on 24th and Harney. Why don't you show up at court? They come into court. It's only if it's necessary. Sometimes the client's out of town or the attorney's out of town. We'll accommodate if we can. Lawyers from Lincoln, they'll come up here for a 5-minute hearing. If I can get them to appear by WebEx, Zoom, phone, I'll do it. I don't want to make somebody drive up here, charge their client 2 or 3 hours worth of billing time if I can get them in and out in 5 minutes. I'll do that. I'm sure the other judges will too. Number 2, be prepared. These are things you learn in law school, trial practice. Be prepared. Number 3, dress appropriately. Sometimes people come in without a tie or without a jacket. I'm not going to pick on people. It happens. Attorneys get a call that they have a hearing that they didn't know about if they come in. I'm not going to jump down people's throats, but try to dress appropriately. We have ethical rules as far as dress code that we're supposed to follow. Today, I'm wearing a coat. I never wear a coat. I haven't had a coat in this courthouse in years. But I figured if Justice Connolly is going to be here with a coat and tie, I can do it too.
You have a robe though.
Yeah. So I'd very much like to take this coat off right now, but I will maintain proper decorum. But I'm making a point. Try to dress appropriately for court. When you file a motion or a petition or an application and you're asking for affirmative relief or you're asking for a hearing date, please include your orders. Leave dates and times in court blank. I get a lot of filings where there's affirmative relief requested, and I'm tasked with drafting an order. It's not my request. We ask the attorneys to have their orders or proposed orders prepared and copy in the other side. Also, in your filings, if the other side's not objecting, please include that. We'll sign off on the orders right away. Not a problem. Please have that prepared and ready to go. Let's see here. Be nice to our staff. These folks don't make enough money to have people chew on them. We've had pro se people who come in who lose their cool pretty easily. We understand that. We also have occasions where lawyers come in and start yelling at our staff. That doesn't bode very well for the lawyer because their reputation gets out there. And it happens. And it's not a good thing for our staff because they get frustrated. They don't know what to do. They come to us, and then we have to play the heavy. And we don't really like doing that. Most lawyers have learned in law school to handle themselves appropriately in the clerk's office and to handle themselves appropriately in the courtroom. So we ask the attorneys to make sure they do that. I'm not here to scold. I'm not here to insult. Just asking you to be nice to our staff. They try to help as much as they can, and they're not allowed to give legal advice. They are frequently asked to give legal advice, even by lawyers, and they politely decline. Not a surprise. Okay, let's see here. Do lean on colleagues. Do lean on other lawyers. Do lean on the judges. If there's something that you want to know, how we do something, come and ask us. Send an email. Make a phone call. We'll try to get back to you. Might not be immediately, but we'll try to get back. Try to help you out if we can. Don'ts. Don't be late. If you're running late, please let us know. Please let our staff know. Contact the administrator's office. Send us an email. Contact the bailiff or the secretary. Just let us know. For example, with regard to public defenders, they're in many cases in many courtrooms, at the same time handling many cases. We know that, we expect that. So we'll set their cases off to the side, wait for them to get in. Civil cases, however, most of the motions are heard over here in the civil division. But I'm one of the few judges that hears civil motions over in the courthouse. So I expect lawyers to be late. but it's still nice to get word that you're running late and that you're in 4 other courtrooms at the same time and our civil motions are on Thursdays. Just let us know. Believe me, I sat in your seat. I would constantly run late for hearings because I was in 4 or 5 courtrooms at the same time. I just tried to leave a message for the judge saying, I'll be on the way. And some judges like to be first. You'll figure out which judges want to be first. I'm not that way. So if you have a hearing with me and you're running a little bit late, just let me know. I try to accommodate if I can. Let's see what else here. Okay. Don't miss a hearing. We have people who miss hearings. Doesn't look good if your client shows up and you don't. It happens. Believe me, it does happen, and it doesn't look good. Don't ignore the possibility of mediation. We can order it. I only order it if it's absolutely necessary. But it's always a wonderful enlightenment when attorneys come to me and say, we've decided to mediate our issues, in particular in probate court. Right, Ms. Wagner? I'm picking on Ms. Wagner. She's very good at making sure that she has her ducks lined up when she walks into our court. So she's being a good sport by letting me pick on her today. Don't be disrespectful to your opposing counsel, to the opposing clients. Don't be disrespectful in the courtroom. Again, this is law school stuff. I can tell you, we hear attorneys walking out of the courtroom because they're mad at us. And we hear comments and snide comments as they're walking out the doors. We don't forget that stuff. We don't hold it against it. We don't forget it either. It's disrespectful. It's not hard to be polite. It's not hard to be polite to your opponents. This is the nature of this beast is somebody wins and somebody loses. You just have to deal with it and be professional and be respectful. Also, remember, the courtrooms are mic'd up. So whatever you say is recorded. And if you say something inappropriately, the counsel for discipline has and can come in and get our recordings, and they do. Just remember that. Also, on many occasions, media is present. So the media might have your voice on recording. It happens. It happens frequently. Also, be careful of social media. I don't want to preach to the choir, but I know I am a little bit. Be careful of social media. I've never had a social media account. I'm not interested. I don't want one. We know that our names are mentioned in social media, usually not in a good light. People will come to us and say, well, here's what so-and-so said about you. And I said, you know what? I'm still going to sleep tonight. That's their prerogative, but it doesn't look good on them as a practitioner. That's up to them. Just be careful. This building is probably has the thinnest walls in the state. So rumors spread around pretty quickly. So if something's happened or something's said, it gets around quickly. And just be careful about what you say.
Okay. So I'm Francie Riedmann. I am on the Court of Appeals. I've been on the court since 2012. There are 6 of us. We always sit in panels of 3. Our rotations are for 2 months at a time. So 3 judges will sit together for 2 months, and then that panel will change and we'll mix it up. Our goal is on a 24-month period for each of us to sit with each other the same amount of time. Just administratively, that's how we try and do it. So far as cases are concerned, we hear all of the appeals except for attorney discipline cases, capital punishment cases, and cases which challenge the constitutionality of the statute. Those go directly to the Supreme Court. We get direct appeals from the district court. We get direct appeals from the county court in probate type matters. And then if there's an appeal from the county court to the district court, and then there's a further appeal that also goes to us as well. Usually before the cases are assigned to us, the Supreme Court will reach down and take cases from us. Sometimes they do it on petitions to bypass that are filed by the parties. Sometimes they do them based on, all the cases get reviewed by a clerk before they get to the judges. So each of the clerks gives a suggestion. They kind of do a summary of the cases. This is at the Supreme Court level. They do a summary of the cases, and then the Supreme Court votes on whether they want it or whether it can stay with the Court of Appeals. Sometimes on the Court of Appeals, we get going on a case and we realize this is a case of first impression, and we'll ask the chief if he's willing to take the case, and normally the answer is yes. It just alleviates the parties spending extra time and money to get the final resolution that they're going to get, because if it's an issue of first impression and we decide it one way, somebody's going to petition for further review for the Supreme Court to take a look at it as well. So we figure you might as well save your client some time and money and just have it go straight away to the Supreme Court for the final decision. I'm not going to spend a whole lot of time on the rules because they were extremely revamped last year. So I would have to start at rule number 1. So I would strongly suggest that you take a look on the Nebraska Judicial Branch website. The rules are there. Even if, well, particularly if you've practiced a long time in the appellate court, don't rely upon how they used to be, either for numbering or for substance in some instances. I do want to spend just a little bit of time on one rule change that has caused a lot of problems for the practicing bar, and it's fatal. So it's the rule that deals with the Bill of Exceptions, and I think it's like Rule 2-105. The rule now provides when you file your notice of appeal, you must file your precipice for your Bill of Exceptions at the same time, or it will be deemed waived. The rule has no exception for that, except that you can ask to file out of time for good cause. Good cause does not mean I didn't know the rule changed, I didn't have it on my calendar, I thought my associate was going to do that. None of those constitute good cause. And as a prior practitioner, it's heartbreaking for me to deny that motion for an extension of time to file the Bill of Exceptions, because you've basically killed the appellant's case. Unless we can make a decision on the pleadings that are in the transcript before us, if we don't have the trial testimony and we don't have the exhibits, there's very little we can do in regards to what the trial court's order was. So I caution you to please, 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 when you file your notice of appeal, file that precipice for your Bill of Exceptions as well, and your precipice for your transcript. The other change that deals with the Bill of Exceptions has to do with payment of it. So within 7 days of the appellant filing their precipice for the notice of appeal, the court reporter needs to send an estimate of costs. And within 7 days of that estimate of costs being received, the appellant needs to pay it. If any of that doesn't happen, the court reporter is to instruct the clerk of the court to let us know. And again, you have no Bill of Exceptions then. So super, super important if you want to preserve your appeal to make sure that Bill of Exception is timely requested and timely paid for. The other thing that's really, two other things that are really fatal to your client's case is getting that notice of appeal on file within 30 days of the order from which you are appealing. Lots of times we get motions for an extension of time in which to file the notice of appeal. We can't do it. It's by statute, it's jurisdictional. We have absolutely no authority to extend that deadline of those 30 days. And the Supreme Court will tell you the same thing, just can't do it. So if you, and it's the months that have 31 days that throw people. So, you know, if your order comes down on August 5th and you file it on September 5th, you're too late. The only exception is if your deadline falls on a weekend and then you have until Monday, or your deadline falls on a date on which there's a holiday and the courthouse has been closed, and then you get the next date. Personally, I wouldn't wait till the 30th day to try and get that on file, but know that if that does happen on a weekend or a holiday, you do have that extra day. But other than that, if it's not filed with the clerk of the trial court on that date, you've blown your appeal and it's going to get dismissed for lack of jurisdiction. I'd say the third thing that's fatal to your client's case is failing to include assignments of error. So Rule 109 sets forth all the parts of the brief that have to be included, gives you the format, it gives you the layout, and honestly, our clerk's office is so great that if you're doing one for the first time, or you haven't done one for a while, or you know the rules have changed and you want to make sure you're still doing it right, you can call our clerk's office and say, hey, will you send me a copy of a brief? And they will send you a copy of a brief that you can actually follow the format for. So assignment of errors is a required section in the brief. It is the only section of the brief that if you fail to include, you're only going to get plain error review on. Plain error review doesn't get you very far. So make sure that you have a separate section. There's a lot of case law on what constitutes an assignment of error. And basically the answer is it is a separate section in your brief. It's called assignment of errors, and you list them out 1, 2, 3, 4 of what error the trial court committed that you believe needs to be corrected. Putting it in a heading, putting it somewhere else in your brief is not going to meet the qualifications of the rule, at least as our case law goes so far. So make sure you have that assignment of error section. I'd like you to have all the sections that the rule says you should have, but primarily that one. That one's detrimental to your client. Along those same lines is we have this general principle. Errors must be specifically assigned and specifically argued. So if you argue something in your brief and you don't assign it, we're probably not going to address it. Same is true vice versa. If you assign it and you don't argue it, it's also not going to be addressed. And I think one of the biggest issues that we see, and I think it's really, really simple, is if you have 4 assigned errors, you have 4 argument headings. You don't need to be creative. As long as you have your assigned errors in that one section, you can just then take that assigned error and make it your heading. It's such a roadmap for us to know what arguments are going with what assigned error, because honestly, sometimes I'm reading and I'm like, I don't know if this goes to 1, I don't know if this goes to 2, and if it goes to 2, there's no argument on 1. The simple solution is simply 1 argument, or 1 assigned error, 1 argument, 2 assigned errors, 2 arguments. If you want to combine them, just put it at the beginning paragraph. This argument is going to address assigned errors 1 and 2, and then make your argument to us. I'm going to, I guess one of the other things that has to do with like record preparation is when you request the transcript. And I always think this is backwards. I don't know who named these things, but to me a transcript is something that you would read, question, answer. Not so in Nebraska. The transcript contains the pleadings and the orders, the things that were filed with the clerk's office. So make sure you have what you need in your transcript, but not everything. We don't need summonses. We don't need notices that the discovery have been served. I'm less concerned about having too much. I mean, yeah, I can scroll through, everything's electronic now, so I can like page down, and get through it. But what's harmful is when you don't have everything you need. And one of the biggest problems we see are on those appeals that go from county court to district court, and then from district court to us. Because in order for us to have jurisdiction, there had to have been jurisdiction in the district court. Lots of times the transcripts that we get don't have the notice of appeal that was filed to get from county court to district court. So if we can't tell if your appeal was timely from county court to district court, we can't tell if we have jurisdiction. So what our court does, and I can't speak for the Supreme Court because I don't know what they do, but what we will do is we will send out a show cause order, and we'll ask the parties to file a supplemental transcript that includes that notice of appeal so that we can do that 30-day calculation to make sure that it's timely in the district court, so we know that it's also timely in our court. So whatever order that you're appealing from, make sure that's included. The motion that you filed to get to that order, if that's what it results from, we need a copy of that. I know it's hard because you're all so familiar with the trial, especially if you're the trial attorney. I think it's easier, and this is kind of my plug for appellate lawyers, not necessarily being the people who actually tried the case, because they're fresh eyes. They know what's missing. They know what the record what contains and what it doesn't contain. But I know it's easy when you're the trial lawyer to just be so familiar with things that you kind of forget that we don't have any idea what your case is about until we get your brief. So the more guidance you can give us on that, the better. Things that we love to see primarily in our briefs, and that's mostly what I talk about because we dispose of so many cases without oral argument anymore, and we do that for a couple of reasons. One, to expedite it. We don't want county court judges telling us we're not speedy as them. So we really do try to expedite our decisions. There are a lot of things that are beyond our control. If a party, well, and one of our big problems lately has been with the court reporters not getting the bill of exceptions in time and requests extension after extension after extension to get that bill to us, because we can't start working on a case until we have that bill. And actually, you all can't start working on your case till you have that bill, because you can't write your brief without being able to cite to it. So the first holdup comes in not getting the bill of exceptions timely from the court reporters. And then there's extensions of briefs. If you've noticed and have filed a request for an extension of time to file your brief, you're getting a whole lot less time than you might be used to. Part of that, again, is we're just trying to move these cases along. Your client wants a resolution, and we're there to help them get it. We don't want to shortchange anybody. I mean, and if you have good cause for another extension, it will be entertained and probably granted. But just the general, I have a heavy caseload, I haven't been able to get to it, you'll probably get one extension, but you're probably not going to get a second one on top of it. So things that I really do like, now that I kind of talked about things I don't like, hyperlinks. Now that everything is electronic, I think it is so slick for us to get a brief in that's hyperlinked to like the bill of exceptions. So most of us on our court have two screens. So when I start working on a case, I pull up the brief on one screen and I pull up the bill of exceptions on the other. And if I have a brief that has hyperlinked to the citations in the bill of exceptions, it makes things so fast for me, because I can just click on the link and verify what's being said is what's being what was said is what's being represented. And I do it, unfortunately, because we have had so many times when it's not. When I go to the page in the line and I read it, like, that's not exactly that's not what that says. So I do go through and I check those citations. It's not just an exercise in blue booking for you all. It's really helpful to us, and we do go back and verify that that's what actually happened in the trial court. So I love if you can hyperlink. I'm not technologically inclined, so I can't tell you how to do it, but I can tell you that I like it when it's done. Same thing for cases. You can hyperlink cases, and we've seen a lot more of that, but I will caution you, a lot of the briefs that we get when we click on that hyperlink takes us to Decisis. It's the logon page for Decisis. I don't have Decisis. I mean, I suppose I do because I paid my voluntary dues, so I think I have it for free, but I don't have an account. I don't have it all set up. So if I click on it and it takes me to the page on Decisis, I'm probably just going to put it back into Westlaw and type in the case and pull it up that way. If you want to hyperlink your case, do it to the judicial branch, because from, I don't know, 2004 maybe and later, Those cases are actually on the judicial branch website. If you go to like the Supreme Court and you go to opinions, they're all on there and you can pull them up and you can hyperlink them that way. Then we don't get any logon page. We just go straight to the case. So if you're a voluntary member and you, well, I think actually everybody has access to that. So I would suggest doing it that way. If you link it to Westlaw, it again takes me to my Westlaw sign-on page. So to avoid the sign-on issue, I would suggest the judicial website. I'm a big advocate of visuals in your briefs. If you can put in a chart, a picture, preferably something that's been an exhibit that's offered and received, as opposed to introducing new material to us, it's so helpful, especially in cases that involve land, water, directional things. It's just so much easier to have that diagram or whatever embedded into the brief itself rather than go to the exhibits and pull that up. Same thing, I'm big on chronologies if those dates are important. If the dates aren't important, my brain can't hold all of that information. If you want to tell me every single date that something happened, by the time I get to like the fourth one, I just can't keep it straight anymore. But for the dates that are important, I love that chart. You know, you can give me the whole narrative, but then if you just put it in a chart, it just makes it so much easier for me to remember. And now, wow, I realize I'm saying how you should make my job easier, but it's not really what I mean. I'm trying to just give you practice pointers of things that go a long way with our court. So somebody brought this up. We had an opening of the term CLE, and somebody brought up using all caps for propositions of law. There's a lot of briefs that have it, and we're thinking that maybe somewhere along the way, way back when, it was required maybe in the rules, and then people just never stopped doing it. I don't know if you all like everything in all caps, but what I don't like when I do something in all caps is spell check doesn't really work very well. There's a whole lot of errors when you put things in all caps that don't get caught by spell check. I don't think we require anything in all caps, so if you dislike it, don't feel like you need to do it because we sure don't require it. For those of you who do criminal law and criminal appeals, if you haven't become aware of State versus MRSA, and you're going to make an ineffective assistance of counsel claim on direct appeal, you need to specifically assign how counsel was ineffective. That general assignment of error, counsel was ineffective in representing me, is not going to get you a review at all. It's not even going to be a plain error review. State v. MRSA now requires you to set out in your assignment of errors how counsel was ineffective in failing to object during voir dire or for whatever specific things. It's going to make your assignment of errors longer, but it's also going to get you review of how you think counsel was ineffective. I guess the only other thing that I would suggest at my detriment is the rules provide for a reply brief. I would say we get a reply brief in less than 20% of the cases. It's the appellant's opportunity to have the last word. So I'm always really surprised that people don't take advantage of it. And where I'm really surprised is when there's a cross appeal by the appellee and then the appellant doesn't file another brief. I had a case where I'm reading the cross appeal and I'm thinking, whoa, those are some really good arguments. I wonder what the appellant has to say about that. Nothing. Zero. And we didn't have oral argument. So the appellant had no response whatsoever to the cross appeal that was filed. So I would strongly encourage you, if you're the appellant or you're in a position where there's an opportunity for a cross appeal, or to opportunity to file a reply brief, I would definitely file that reply brief so you can get the final word in. So with that, if there's any questions, I'm happy to answer them. Yes? Well, so if it's an exhibit that you're using, I think you can just embed it right in your like argument section or your analysis section, wherever you're putting it, and then just cite it like you would. If it's exhibit 31, cite it just like you would exhibit 31.
But if it's not an exhibit, it can't be you can't make up a new chart.
I wouldn't suggest making up a new chart. If you're doing a chronology, I think you can say, in summary, and then put your chronology in there. But yeah, for pictures or charts or something that's been offered as an exhibit, I think it's helpful. Anything else? Yes.
On the paying for the bill of exceptions, I'm aware of a case where somebody got to show cause to show why it wasn't paid, and it turns out there was some confusion in that. What's the ramification? Paying outside of the deadline or not following?
Depends on the reason, I think, honestly. So maybe a well-kept secret is we have a motions judge. It doesn't rotate right now. So there is one judge on the court that is getting all of the motions right now. And it's up to that judge to determine whether cause has been shown. I know we had one on payment amount issue where there was like miscommunication on the amount and such. And then it was allowed to be paid late because the full amount wasn't paid because there was a reason why there was a misunderstanding as to that. But it's mostly I got the bill, I got the estimate of cost, and I didn't pay it. I forgot, it got filed, I gave it to my office manager. We have let that one go, where it was given to someone else in the office to pay, and then there was an affidavit from the office person who thought it had been paid and realized that she didn't get it paid. So we did let that one go. Oh, there won't be a bill of exceptions. It won't be forwarded. So there won't be a bill of exception. Yeah, the court reporter is not supposed to forward it until it's been paid for. Okay, thank you.
All right. Push the button. If you don't abide by all the things she just said, the trial court judges will really appreciate that. I'm just kidding. No, really. Pay attention and do what she said. Just a couple of things really quick. My name is Judge Nathan Cox. I am down in Sarpy County as district court judge. I'm the newest district court judge down there. And so I'm still in the learning process, and hope I'll be in the learning process the remaining time that I'm there. There's always something new to learn. I'll be really quick. First of all, there was a question about attorneys being able to talk to their clients in a Zoom hearing. There is what's called breakout rooms. I use that frequently when I have individuals that need to talk, and I just put them off in a breakout room, and then they're able to discuss whatever they want to discuss, and then they come back in as soon as they're done with that. I've still continued to use Zoom a lot. In fact, anything that is a non-evidentiary hearing, I try to do as a Zoom hearing, just because I think that it saves litigants and time and money, and the attorney's time as well. So if it's an evidentiary hearing, then I think the statute requires that there be an agreement by the parties and consent of the court. And so if that's the situation, then you need to follow the statute so that we're in compliance with that. I still use Zoom a lot. Next thing that I wanted to touch on is docketing versus individual hearings. Down in Sarpy, we still use docketing, docket calls. So we've got, for example, my criminal cases, we'll have just one time that everybody will show up for statuses for pre-trials, and we just go through them as fast as we can. Some of the judges do that with their domestic, some don't. I have gotten to the point with statuses and temporary hearings, etc., that I just set them individually at 15-minute intervals and then just go as hard and fast as I can to get through those. I hear a lot from attorneys that here in Douglas that they get one shot at temporaries. I don't know if that's the case or not. What I tell my litigants is things are very fluid in the beginning stages of domestic cases, and so we can have as many domestic temporary hearings as we need. And I haven't had any attorneys abuse that at all. We've got a great bar, and so there are frequently times where I'll get temporaries coming in, and I'll make time for my usual calendar and after my calendar, because I don't do those on the record, to try and accommodate and try to address issues up front. And I also try to tell litigants that just because it's temporary doesn't mean that that's going to be the ultimate decision of the court. I think that would be an absurd position for me at the early stages of litigation to set in concrete something that I haven't even heard the evidence on. So that kind of, I think, takes a little bit of the tension of the temporaries out, because I kind of got that sense from a lot of attorneys that this is my one bite and then it's going to be set in concrete and this is what you're going to, and so they're really tense at the temporaries, and that's not what we've been doing down in Sarpy. Dues, make a clear record. My bailiff struggles with attorneys calling regularly and saying, can you just continue this, or can you just do this, or can you just do that? There's no motion on file, there's nothing on file, and I just tell them no. You need to make a record. It needs to be such that on appeal, Justice Riedmann can look over it and see that, all of the steps were taken and the court isn't just randomly continuing things and, because I felt like it. So there's a record, and that's important. The other thing that I encourage attorneys to do is talk amongst yourselves. If there's a continuance that nobody is contesting, just send a proposed order over that is signed off by opposing counsel saying, this looks good. I don't have a problem with it, essentially, and I'll sign off on it. I'm not going to drag you in over something that's not contested, and it'll save you a little bit of time and effort in that regard. Everybody else historically has talked about the do's and the don'ts, and a lot of the stuff is ongoing. Please don't wear Magnum PI Hawaii shirts to hearings. That's frowned on generally. There was also an attorney that I harassed, still am harassing, over showing up by a Zoom wearing a wife beater, and I said, oh boy, just turn your camera off. Don't, what are you doing? And so I give him a hard time, and kind of like Judge McDermott said, give them a hard time and try to impress upon them that we need to be professional even if we're appearing via Zoom. So anyway, those are some don'ts, some low-hanging fruit that don'ts. With regard to questions, I don't want to eat up a lot of time or keep you here on a Friday afternoon. I'll just jump right into questions. Does anybody have questions? Yes, sir. Thank you. I can speak for myself, and I remember a judge when I was practicing telling me that he had only deviated off of his initial sentence that he had thought before going into the hearing only once because of what the state said. That was a little troubling, and it was something that kind of stuck with me. That, you know, what's the point of doing this if there's not going to be? Oh, I'm sorry. What's the point of having the arguments at sentencing if it's not going to make any difference? And so I can tell you in my time on the bench that I have changed my sentence multiple times because of arguments that have been made. I've told the parties I was thinking about something more serious or less. I'll tell them that I need more time to consider this because of the issues that have been brought up at allocution. And I don't have a problem with doing that. It's an important enough issue. You know, I mean, you're talking about the life of a person to take the time that you need to do it. And so for me, I listen, and I've changed my sentencing thoughts as a result of what attorneys have argued. So I don't know. Did you want to speak it?
So in Douglas County, I know, coming from the same office that Mr. Sigler is in, there was kind of a, have you will, the state really didn't say a whole lot, or there were these agreements where the state would remain silent. Being new to the bench and on the bench since 2021, I've noticed that it seems that, and I think my colleagues are the same, that the only cases that seem of importance sometimes to the state are those where you've got the attorney who handled the trial or handled the plea that are appearing, because a lot of times there aren't statements by the state. There's always allocution by defense counsel in criminal cases, and sometimes those are a little lengthier than they need to be. But I do think that hearing from the state, because there are a lot of sentences that, you know, I have the background in knowing kind of the range of certain things, but would like to hear from both sides. And there have been several times where, based on what the state has said, or more often the defense has said, that I've changed what the sentence is. And I know my colleagues have said too that they'd like to hear from both sides. Not all of them, but majority.
Any other questions? Last comment that I have is the cheapest therapy that you'll get to keep yourself sane in the practice is find somebody to go out to lunch with. It's expensive to go out to lunch anymore. I realize that, and it keeps going up. But compared to therapy, it's awfully cheap. The judges on both the county and the district court bench go out to lunch on a regular basis, and it's just frequently a detoxing time that you're just frustrated with things, and that you're struggling with issues or whatever, and you just have an opportunity to just kind of sit around with people that know what you're struggling with, and they can just kind of shake their head and go, yeah, or they don't even have to respond. But it's the cheapest therapy you'll get, and I just encourage you to do that. And besides that, you'll develop great friendships that will take you well into retirement. So at least that's been what I've seen. So with that, is there anything else? Thank you very much.
Thank you, Dave. How many here have tried an arbitration case? Well, you probably realize that in recent years there's been a profound shift in litigation, and mandatory binding arbitration permeates our legal landscape. Research shows that
Can you get closer to the microphone?
75% of the 44 largest banks in the country, thank you, require mandatory arbitration. So it really affects our culture, and it affects your life if you don't realize it already, because it's prevalent in employment contracts. It's also prevalent in your buying and selling stock with EG vendors or Schwab or Ameritrade. And even if you're buying and selling a house here in Omaha, the standard real estate contract has an arbitration clause. You can opt out of it, but I seldom see the parties do that. So it's here to stay. Now, the advocates for mandatory arbitration cite different reasons why it's beneficial as an alternative dispute resolution. Of course, it eliminates jury trials. They advocate or suggest that it's cheaper. I don't know about that. It's faster. It is faster. The average consumer case under the AAA American Arbitration case from the time of the filing of the demand to the resolution of the award is 6.7 months. Commercial is about 7 months. While in the U.S. District Court here in Omaha, filing of a petition or complaint and the resolution takes about 27 months. So it may be faster. They also, those supporters of arbitration, like privacy. And by privacy, I mean the parties can agree that any of the underlying facts that were produced in evidence or the result will remain private. And so if you think of Google, Amazon, Harvey Weinstein, arbitration can be more flexible. Unlike the overcrowded court calendars, the arbitration can be scheduled around the parties and the arbitrator's schedule. In addition, they like the simplified rules of evidence and procedure. Discovery can be rather limited, and the procedural disputes can be handled by a phone call to the arbitrator. And what they really like is finality. And by that I mean there's very limited recourse on appeal from arbitrators' award. It's really very limited. So you better make your case before the arbitrator, because most likely you're not going to get it reversed or in district court. Of course, the cons of the arbitration is it eliminates the jury trial, and of course there's a lack of transparency. But probably the most complaint in arbitration is its lack of fairness, and that means the lack of objectivity in selecting the arbitrator. And selecting an arbitrator is kind of like a crapshoot. It's probably the most crucial decision or choice you're going to make in the whole procedure. And there's not a lot of information out there to help you. You probably would want to go to the arbitrator's resume, and that will show the arbitrator's work history and educational background. And if it's a local arbitrator, you might ask other lawyers that know that person has had experience with it. But a lot of times in this arbitration under the American Arbitration Association, it is necessary that you're going to get a local arbitrator. So look upon the arbitrator as a one-person juror. Now, during my time as an arbitrator, I've experienced trial lawyers that fumble and flail through the procedure, particularly the evidence hearing. It may be because of looser rules. You're not in the courtroom. The expectations are more blurry, and so they have a difficult time finding the balance in that hearing room. And I'm here today, and I hope to impart to you some do's and don'ts about handling the arbitration procedure. One, know the rules of the road. By that I mean, look at the arbitration agreement very carefully. Scrutinize the arbitration clause, because that's very important. In that clause, will set forth almost everything. It'll tell you what procedural and substantive law is going to be applied. It'll set out the venue. It'll tell you how many arbitrators. It'll tell you if there's going to be limited discovery. It'll tell you what type of award is going to be called for. Now, there's 3 types of awards. The standard award, and that is an award where the arbitrator just sets out the facts and the party's contention, and then concludes claimant wins or respondent loses, or claimant wins X amount of dollars. The next type of award is a reasoned award, and that's more like an opinion, an appellate opinion. The arbitrator will set out the facts, the parties' contentions, the law, and then how the arbitrator applied the law, the facts to the law. The next thing you need to know or look at under knowing the rules of the road is the what organization, the administrative body that is administrating the arbitration. I'm a panelist on the American Arbitration Association. They have certain rules and procedures, and those rules you should be aware of because they could affect limiting discovery, how you discover, procedural rules such as subpoenas, procedural rules such as types of the award, and whether what type of evidence will be admissible. Some arbitration agreements mandate that the federal rules of evidence apply. Others are silent on it. Also, it'll tell you what type of award will be required. The demand by the claimant or the statement of the claim is what starts the arbitration. And the respondent then has a right to file an answer statement. The form that you get, at least from the AAA, will have a little box where you set out your claim or demand. I urge you I've seen parties just put breach of contract for X amount of goods, respondent breach of contract, damages of $600,000 or whatever. If your goal is persuasion, you don't want to do that. You want to say, see attached narrative. And in that narrative, set out all the facts of the case and how you arrived at your damages. Now, the respondent in an answer statement does not have to answer line by line, but should give a narrative and set out the affirmative defenses. Because on some rules, at least in AAA, if you do not follow a respondent statement, then it's deemed to be a general denial. And if you forget to amend and file an amended statement, then you're going into a hearing with a general denial, and you're not going to be able to put your affirmative defenses in. So it's very important to make sure that procedurally you have what you want for the arbitrator to decide. So that my do's and don'ts there is do not do the bare minimum of the pleadings. And I've seen that happen so often. They think, well, we're in arbitration, it's so informal, and the arbitrator will be able to figure things out. The next stage after the filing of the demand, the organization, the administrative organization, will submit to the parties a list of arbitrators. And then the parties will select the arbitrator, whether it's one or a panel of three. Now, if the parties do not agree, then the organization will select the arbitrator. Like I said previously, this is probably the most critical choice that you have, because it's like a crapshoot. You really don't know what you're getting. But you can minimize that by looking at the resume. Once the arbitrator has been appointed, he'll schedule a preliminary hearing. And think of a preliminary arbitration as a pretrial conference in trial courts. This is usually done by telephone. And I think it's a good idea, and I urge you to have your client on the phone and be a participant, or at least listen in to the preliminary hearing procedure. At that time, well, first of all, the clients may have not ever been in arbitration. They may think it's very informal, that you just sit around a table and you tell your story, the other side tells their story, and then the arbitrator comes up with some figure. You ought to disabuse that idea real quickly. So at the pre-hearing, the arbitrator and the parties will discuss the scope of discovery, the dates for exchanging documents, deadlines for exhibit lists, dates for exchanging expert witness lists, whether the parties have tend to file pre-hearing motions, and how much each side will have to present their case. Also, it will be decided at that time whether a court reporter will be required. And also, at that time, we'll discuss the award again, and I've already covered what types of award the parties will want. After the preliminary hearing, the arbitrator then has a pretty good idea of what's involved, how many days of trial. So the administrative organization requires the arbitrator to file an estimate of the fees. And so the arbitrator will submit a written estimate of the fees, estimating what the fees are going to be for the whole proceeding. And then once the organization has that, they send notice to the parties, and then the parties will have to split those fees, which brings me back to the selection of an arbitrator. I have been on a three-person panel, and the dispute probably was $250,000 to $300,000. Well, there's three arbitrators. My fee is $300 an hour. Had two arbitrators from Chicago, and their fees were $500, $600. So through that whole proceeding, we had arbitrator fees of $60,000, $70,000, $80,000. Now that all could have been alleviated, even though the agreement may have called for initially three persons on that panel, by counsel suggesting to the other counsel, if it's not a complicated case in this one, why don't we just do it with one arbitrator? And so you might think of that if you see you're required a three-person panel and your case really doesn't call for it, see if the opposing counsel will agree to one. It'll save your client a lot of money. On pre-hearing motions, you probably should consider whether necessary or they're going to be productive. And that depends on the complexity and the nuances of the case involved. Under the AAA rules on summary judgment, you can, summary judgment, they call it summary disposition or arbitration. You cannot file a summary disposition motion without getting permission from the arbitrator. The arbitrator will require a 3 to 5 page brief setting out why you think a summary judgment would be successful. And it's my experience, arbitrators disfavor summary disposition. For one reason, there's the limited rights to appeal. The arbitrator wants to get as much evidence in as possible. Now, I have, over the 7 years, I think 2 summary judgments. It was so close, so clear on the law that there's nothing that the respondent could have done to create a genuine issue of fact. On production of documents, that can be limited by the arbitration agreement. So you have to look at that. But like I said, you should consider whether it's necessary. I did handle a case which was substantial, thousands and thousands of dollars, and it was a breach of fiduciary duty. It was one limited partnership, and the partners created another limited partnership, and that partnership was in competition with the original limited partnership. I was a successor arbitrator on that case, and the first arbitrator really limited the discovery in that case, and you know it's going to be a question of damages and how much was siphoned off. Well, that arbitrator, for some reason, refused the claimant the tax returns of the limited partners and the limited partnership. Well, I was really surprised and shocked because there's no way that the claimant was going to be able to prove the damages of tax returns. So I did grant the protection, and the claimant did prevail eventually, and I awarded a substantial sum. So you should consider whether it's going to be productive. And like I said, hope that you get an arbitrator that does not have a closed mind based on a minimum production documents. After the next stage, after the pre-trial hearing and the production of documents, there's what's called a pre-hearing. And usually that's about a month before the actual evidentiary hearing. And at that time, the arbitrator and parties will discuss the handling of exhibits, whether they're going to be digital or hard copy. Now, I prefer hard copy, but if it's a really complicated case with a lot of exhibits, it makes sense to do a digital method. Also, at that pre-hearing, the parties will, and the arbitrator will discuss the witness's testimony. You'll have a list of the witness lists, what they're going to testify to, and also how they're going to testify, whether it'll be live deposition or sometimes by telephone. Sometimes the counsel will want to do a witness's written statement. Well, that's not going to go very far, at least in my mind, because even though the rules are loose, they're not that loose. And then the discussion will center on whether you're going to be in present. The hearing will be live or will be by Zoom. And I, like some of you, I'm not all that technologically competent, so I refuse to be the host on a Zoom. There's just too much going on, marking exhibits, listening to the testimony. But one of the parties will be the sponsoring host. And so at that time, you have a pretty good idea how things are going to work out. Now, the evidentiary hearing. Like I've said, I've seen experienced counsel kind of fumble and fail at times. I suggest that you do not waive oral opening statement. This gives the arbitrator an opportunity to hear your position, because sometimes some arbitrators probably assimilate information better orally than by written instrument like a brief. So I suggest that you don't waive opening statements. But if you're going to give one, I would limit it to about 10 minutes and be ready for questions from the arbitrator and be ready to answer them. So if you, let me say this, the arbitrator might hint, well, look, I've read your pretrial briefs. I've got a pretty good idea. Don't let that deter you from doing a opening statement. Also, even though the evidentiary rules are loose and they may not apply, make your objections. Let the arbitrator know that you're on the ball, and when you make those objections, even though you know that probably the evidence is coming in, at the same time, mention why it has no weight or very little weight. And then when you do your post-hearing briefs, then really lay it on why it's not no consequence, or the arbitrator should not give it much weight. Also, show the arbitrator your math. Treat it like you're trying it to a jury. Put on a strong evidence on your damages. The myth about arbitrators being splitting the baby, I'm not so sure that's correct, because what happens is the claimant or the cross respondent fails to prove the damages. And so if you got something that's a case of emotional distress, Iowa has that under their employment discrimination, put somebody else other than just the claimant. Put the wife or the spouse, adult child, or some neighbors. I tried a case, and I just waited for, I know I didn't want them to necessarily call a doctor, but I wanted a little more evidence on the suffering, and I didn't get it. So show the arbitrator math, and if you have an expert, prepare a sheet for the arbitrator to submit, demonstrative evidence, because when we go back, it's very helpful without having to. We will go to the record if there is a court-reported record. But it's really handy to have a sheet that you can just look at and how you calculated your damages. Please, no small talk with the arbitrator. You wouldn't do that with the trial judge. You probably wouldn't have the opportunity, because the trial judge has someplace to go at breaks. You can go to chambers. The arbitrator is in this closed room with witnesses and the parties. And invariably, the counsel want to make small talk in front of the parties or the witnesses. And this gives off the idea that somehow the fix is in, or there's the arbitrator may not be impartial. So
the arbitrator didn't have any place to go unless it's out in the hallway. So, and another thing, this personal sniping, it just does not get you anywhere. And I see that more in arbitration than you would in the trial courts, because the trial courts have a lot more control over the parties and the litigants. And they won't tolerate it because, one, they have the power of contempt, and they have a sheriff there, and they also have a real power of sanctions. Well, the arbitrator doesn't have that. So when they start sniping, and I think maybe it's because they're not in the courtroom and they don't see the judge in the black robe, and it's just a layperson arbitrator that they do that. But it's really counterproductive, and arbitrators are human. They can see who may be the instigator, who is really pushing this nonsense, and so my advice is don't do it. After the evidentiary hearing, well, let me get back to the evidentiary hearing. Again, I wouldn't waive oral argument. Now, the arbitrator will say, well, I can hear it in post-hearing briefs, but this is a chance to sum it up and really concisely say it in about 10 minutes. I find that very helpful. After the oral argument, then there'll be post-hearing briefs. And on the post-hearing briefs, remember, like the trial judges here, they don't have clerks. Arbitrators don't have clerks. So make copies for the arbitrator of the important cases that you're relying on. And again, I can't emphasize this more. In the oral closing argument and in your post-hearing briefs, tell the arbitrator what you want. Spell it out for the arbitrator. And again, spell out how you calculated your damages. Invariably, I don't have the evidence to do what I think I want to do because counsel took a shortcut. So think like you're trying to a jury and put the damage evidence in and put a lot of it in. With that, by the way, then after the briefs are in, the arbitrator has 30 days to make an award. And like I said, the award can be one of three ways. It could be a standard award, it can be a reason award, or it can be an award by findings of fact and findings of law and conclusions of law, rather. Now, again, I give you a tip here. Findings of fact and conclusions of law, an award, that's really labor intensive for an arbitrator. And a lot of times the arbitrator will ask counsel to propose their findings of facts and conclusions of law. It's a lot more cheaper, less expensive for the client if counsel can agree on a reasoned award. And so that would, I would urge you to think about that anyway. Are there any questions?
I have one, Justice Connolly. What's the longest hearing that you've had on the evidence? Is it more than a day, 2 days?
2 weeks.
2 weeks? Wow.
My question is, do you have any tips for the practitioner on how to get the court's attention? Sometimes people will come to me and say, I really thought I had an important point, and they're not even asking for oral argument. Is my question dense? Or how do you get a judge to get interested in your appeal?
Speaking from the Supreme Court, first of all, petitions for further review from the Court of Appeals to the Supreme Court, if you're asking for that, you have to get the court's attention right away. And you have to somehow, at the very beginning of the brief, say why it's important, it's bad precedent, they went too far, et cetera, et cetera. Otherwise, if you wait until page 10, 15, they're lost and you're not going to get that granted. Now, to the question of the briefs in the Supreme Court, and I don't think the rules have changed. The judge that assigned the case will read the briefs thoroughly. The clerks will work the record. The other judges, the non-author judges, will read the briefs. Probably if it's a post-conviction with no new law, they can skim over it. If it's a question of a complicated question like the difference between equitable subrogation or legal subrogation, then the red flags are going to go up and they're going to read that brief very carefully.
And I'll just add, we too have an author judge, but we read every brief. I mean, not just our clerks read it. We as judges read every brief that we're on the panel for. Our clerks have no say in whether a case gets oral argument or not. That's a decision that's made by us as judges. And it truly is issue driven. If we've got case law that answers the question and the facts aren't funky, then it's probably not going to get the oral argument.
Thank you.
Judge Riedmann, I have a question. You mentioned petitions to bypass, and I was going to ask, how often does that happen, and how successful are they?
Well, when I was on the court, if it's a high-profile case with a lot of publicity, the court would probably grant it. If it's a issue of maybe first impression, the court would grant it. And sometimes if it's just something that's one of the judges think it would be good to handle, then you need 4 votes to get it.
I would just add post-COVID, I think the chances of it getting granted are higher simply because our numbers are lower. The number of cases that are getting appealed are lower, and the Supreme Court has a lot more they hear oral argument on almost every single case they decide. So they like to have a full docket. They like to have, their 4 days with 4 cases each. So I think they're more likely to grant them now while the numbers are low than they had been in the past. But again, that too is issue driven.
However, for Justice Connolly, given the extremely narrow opportunities for review on a AAA or an arbitration court, what are the practical rationales for requesting the different levels of reasoning from the arbitrator rather than satisfaction of informed curiosity? If I get a facts and conclusions versus.
Well, sometimes a party wants to know why they lost or won. I'm not saying you can't get an award vacated. I'm just saying it's very difficult. There's substantial law out there that the arbitrator can even be wrong on the law, and it won't be reversed or vacated.
Thank you, Justice Connolly. Appreciate it. And last, but certainly not least, Executive Council Member, Judge Allen.
Thank you, Dave. So I'm the last one standing between you and your weekend, so I will not belabor the point. I will just point out for District Court in Douglas County, as Mr. Sigler pointed out, I'm one of the newer judges. However, there are 7 that have been appointed after me, and that's since 2021. So the biggest thing with Douglas County District Court is the number of new judges that you have. the majority of them having come from the criminal arena. And then also the moves. There's been a lot of movement and people not knowing where different people are. And just so you know, there is one district court judge, Judge Benson, is up in juvenile, in what was the juvenile court area. They're making renovations to put Judge Vaughn, who is the newest member of the district court, up there as well. So just for logistics of kind of the bench and where everyone is at. That being said, I much like Judge Cox, don't pretend to know everything. I came from 25 years of criminal prosecution. And so there are many times where I will flat out ask, explain this to me, to some of the civil as well as the domestic. And so with that, I always encourage you to, with the bench being what it is, to, politely and respectfully bring up why an issue shouldn't be what it is. All of them that are appointed after have different, with the exception of Engelman, who gives those domestic folks quite an entertaining time, and yet is a little more forceful. We go to him with a lot of the domestic questions. But just in speaking with my staff, because you have 18 different personalities up there, and district court is not like county court where things kind of run on a schedule or daily things. Each court handles things differently. Each court has different rules. We all follow, obviously, the local rules. And I can tell you one that we have recently spoken about, that how you will find most of the courts starting to enforce, is the meet and confer prior to motions to compel. It's something that we discussed. I think some of the judges who have been around wasn't aware that it was actually in the local rules that prior to filing a motion to compel, their parties should meet and confer. And so several courts, mine in particular, if you call to get a motion to compel date, my bailiff will ask, have you met and conferred with the other side? And if the response is they won't return my call, then she will send an email out to both parties instructing that the court will entertain sanctions if this email is not addressed by both parties. And if there's no response from that, then we will give a motion to compel hearing date. With some of the other things, WebEx District Court is not using it as much. We do still use it a lot for accommodating the criminal cases, prisoners namely. My court, if both parties agree and it's something that is a simple status or a pretrial, and both parties agree, I will allow WebEx. If no one requests it, then we're in person in courtroom 414. Some of the bigger things coming from the arena that I come from, I like to, and it's different, I think, for the civil and domestic lawyers, I want to keep a handle on all of my cases. So you'll get status, show cause and status orders from me, that if a case has just been sitting there and there hasn't been anything going on, I'm going to set a status to show me why I shouldn't dismiss this so that it's off my docket. And that's just kind of now, as the cases are coming in, all of my civil and domestic cases are immediately an order sent out for mediation. And then after that mediation, there's a status hearing date set. And then I'll continue those statuses just so that I can keep track. So in my courtroom, I'm wanting to keep the cases moving and not letting them, if I see something that's sitting there longer than 400 days, it gives me hives. So I do try to just continue hearings. And with temporaries, as Judge Cox stated with regards to Douglas County, my court's one that typically I won't hear further temporaries, because I feel like if there's something that has changed, then there's the ex parte out there, which is what the change is for, short of getting the matter set for trial. However, those that practice domestic in front of me, if it's something that I think is fluid or that is going to change, I automatically will set a status to see how things are going myself. So if you're calling my court wanting a further hearing, you may get a further temporary, you may get some resistance from my bailiff. And as all of the judges here have said, respect the staff. They don't, while they run the courtroom, they don't run us. They can't make us do anything quicker or anything. So they tell you what they've been instructed by their judge. And so it's not appropriate nor the right avenue for you to disregard what they're trying to tell you that they've been instructed by their judge. So she will tell you that. She does listen, however, if there's some extreme circumstances. But as I said, the way my court looks at it is you have the option to do an ex parte if it's something that really necessarily requires change of a temporary. Some of the don'ts, we get a lot of, there's been a hearing scheduled, and when the first person calls to ask for the hearing, it's 15 minutes. And then opposing counsel sees that there's a hearing for 15 minutes, so then they just add a whole bunch more motions to that, and there's only 15 minutes. My courtroom is one that is very timely, having been in your shoes, and will never forget being a person who practiced that had to sit for 30 minutes because the hearing before me ran over, and now I'm late for the rest of my day. I try to make things run on time. So if you know you need an hour, ask for an hour. If you're trying to schedule something within 15 minutes when there's already one motion for 15 minutes, I typically will not hear it. What I will say is, if we get through the hearing that's scheduled for today and there's time, I'll hear it. Otherwise, you need to get with Ms. Coleman to get another date. And specifically along those lines, if your hearing was scheduled at 9:15 and it was for 15 minutes and you show up at 9:30, you'll be instructed by Ms. Coleman that your hearing's been canceled and you need to get another date. The reason for that is not to disrespect anyone at all. It's to make sure that everyone's time is appreciated. And all of you, I know, are aware of situations where you're waiting and now the rest of your day is gone. Similarly, if I've got one counsel there and the other counsel's not there, I'm not going to wait. I'll allow them to leave and tell them another date will be scheduled for this hearing or this motion. Another don't is don't call the court to get a date for an order or for a hearing and then not follow up to secure that date, because then you're showing up for a motion for summary judgment or a motion to dismiss or a pretrial that we don't have scheduled because you never called back to confirm that date. My bailiff will take time to actually hold the date that she gives you and the time that she gives you, but within amount of time, if she doesn't hear back from you, our calendar is just constantly, she schedules me every 15 minutes. So just be mindful that if you call and ask for that date, to make sure that you do that. And with the rules being what they are now, don't file a motion and assume that we know you filed it. If you don't call us to get a hearing date, we don't look at every single thing and know that something's been filed. So if you file the motion, you need to make sure that you're getting a hearing date and not just assuming that we knew that you filed it. And that's with all of district court. The other thing specifically with my court is I like to read everything prior to a hearing. I try to be prepared for every hearing that I have, and so don't send me a brief that's 60 pages, drop it off. The local rules tell you we don't print more than 10 pages, so just make sure that you're dropping that off. And if you have, to save you time, if you've got motions that you're filing that, as I think Judge Cox said, that are unopposed, I get a lot of motions to withdraw that are set for hearing. If you've notified your client or there's no opposition by the other side, or opposing counsel or another attorney has already entered their appearance, my court, you don't need to set that for a hearing. I don't need you to set hearings and then waste your time coming down here on something that I will just automatically sign. So you can always ask my bailiff, is this something that she'll sign, or do we need to actually have a hearing for it? Because if it's unopposed, there's not a reason for you to clog up your calendar with coming to the court. The other thing I'll state is, with the calendars being the way they are, I, in my courtroom, set a lot of backups. And especially, I know domestics are not, I don't know if other judges don't set domestics as backups, but I find that I've got days with nothing, but yet I got people I can't get until April. So I'm starting to set domestic, civil, and criminal backups. So if you are listed as a backup, don't assume that that's going to be continued. We send out trial orders, and so if I've got 3 backups, all 3 of those are coming in on the same day for pretrial. And if the first one went away, I expect the second one to be ready to go, not to ask me for a continuance. I've been pretty liberal in continuances because I am newer and I don't want to get a bad reputation. But in the same sense, when I'm looking at a calendar that I can't get somebody in for a trial until April, I want to definitely make better use of that time and be available for the parties who want to have their cases heard. So in my courtroom, we will be setting backups, and I just don't want people to assume that those will get continued. Last but not least, a couple things my court reporter asked me to do. We actually are a digital courtroom. In district court, there are several that want the paper still and several that want the digital. I'm one who's willing to do either, but because of the new guidelines on appeals with the exhibits having to be electronically filed, I require that all exhibits be sent electronically. However, if we're in a trial and you prefer to use paper exhibits, then you can. My courtroom is one that's set up with all of the current technology. I cannot tell you how to run it. But what I say is be prepared. Don't waste time during our trial, which is your time and your client's time. My court reporter will definitely, if you reach out to her, make time to let you come in and test all of the equipment, test the click share to make sure your computer is compatible with that. And if it's something you've done before, great. If you haven't, definitely reach out. We'll make time within our schedule so that you're ready and that the day we're starting trial, you're not spending time having to figure out the technology. You don't need to provide me with written or documents. You don't need to come with the binders. My court reporter, after you send those to her, sends them to me, and as you're using them, I'm clicking and looking at them myself as you're referring to those. With that, when you're sending them to her electronically, they need to be in individual PDFs, not all 30 exhibits in one PDF. It needs to be exhibit 1 is one, exhibit 2 is a separate one. She usually will send something back to you. And then always, as we've stated, the record is yours. And especially with a lot of us in district court having the electronic court reporters now, it's not like the stenos we're used to who can say, I didn't hear you, I need you to repeat that. It's just blank. So with that, you definitely want to make sure that you're speaking slow enough, you're speaking clear enough, because with the electronic technology, there's not the capability to go back and catch what you had stated. So definitely make sure that you're keeping your record for your clients and for you. I think that's all that I have with the do's and the don'ts. I will tell you that there is a full-length mirror in my courtroom if you have a question of what you're wearing. And if it looks okay, pop in 414 and take a look. But a defense counsel told me that that's what that was there for. So by all means, if you need to fix yourself, definitely pop in and take a look. Any questions?
In the domestic cases, do you think that the settlement facilitation is going to be more prevalent among the district court judges?
We all kind of thought that Engelman's idea was great, so we told him test it out and see how it works, and then explain it all to us. So we're kind of still letting him work through that, but I think that there will be more of us definitely that will go those lines, because it will free up more time, I think, for litigants as well as the courts. Yeah.
Judge, in a civil case, would you clarify your position on murdering mediation? I didn't quite hear what you said.
Yes, so in civil cases, and again, this is just because I want to keep my hands on things and make sure that they're moving forward. So when we get a civil case, namely showing that it's filing or that the scheduling order's been filed, we immediately send out an order to do mediation and then set a status. There are some cases that I've had where they have said, the parties have said mediation is just not going to work. We're too far apart. And I understand that. What I don't like to see happen, though, is the court sends out an order for mediation, and then they come to that status, and then they say, well, one side wants to mediate, the other side doesn't, and then they just thought that it was an option. It's an order by the court to participate in mediation, but it's not one that if both sides don't think, I don't obviously want to make either side do something that's not, that they don't think could be fruitful, but if one side's willing, then I'm always going to say do it. And then the status hearing is to see whether that was successful, and if not, get you on our trial calendar at that point, or get another status set after you think you're through discovery to then set it for trial at that time.
I would love to know your opinion or thoughts on temporary hearings and the appropriate, reasonable length for affidavits for standard cases. I know I have been guilty of submitting lengthy affidavits on non-standard cases, but for the reasonable standard cases, what would be the appropriate length of an affidavit where you're not going to get frustrated with both counsel who are doing excessive reply briefs or both submitting excessive affidavit lengths? So any standard guidance that you can give, or the consensus on the bench that you talked about for temporary hearings for domestic cases, because the fear is if I submit a pretty brief, straightforward affidavit for my client, and on the other side, the responding affidavit is triple, quadruple the amount of pages, then my client feels like I didn't do my job well enough, and if you don't get the outcome that they want, it's because we didn't prepare the affidavits in the same manner.
So I don't know that I can answer that in a catch-all everything. I would love to say that they should be 2 pages. But unfortunately, there are different cases with a lot of different circumstances. I don't stop reading after page 4. But what I will tell you is, having read them before parties coming in, I will ask questions specifically about things that may be in one that are not in another. I'm not going to make a decision based on just because this is in this affidavit. All of my temporaries, as you're aware, are in my chambers. And so I will have a conversation and want to go back and forth. So, I mean, to me, I think that you can get out in the affidavit the brevity of what's being asked for or what is being resisted in the temporary in a few pages, because obviously that's when you keep the attention. But I've had, 34-page affidavits, and I've read them, and I've obviously talked to the other side about, they said this, you didn't mention this. They said that drinking and drugs are an issue, you didn't mention it. So with that, I don't want to say that I'm, think that you could just be 3 pages, but I don't think you need to. He did 35, so I'm going to do 35. I don't think that's necessary at all. And like I said, I think you can get out in a few pages what you're asking for in the temporary. Anything else?
I'm going to be that guy. Last question. You talked a little bit about sanctions, and this is to everybody. I have a feeling in the 5 years that we've been doing the bench bar, there's a move to more sanctions attorney's fees being awarded, being considered by the courts. Am I seeing this right? Am I feeling this right? Is there a change out there afoot?
I will tell you that I will give sanctions and I will give attorney's fees. The basis for that is, if we went to trial to do the same things that were initially talked about and tried to resolve, but we still went to trial and it's the same resolution, I'm going to consider attorney's fees. Motions to compel on sanctions where they're have to come to me the 2nd and 3rd time. Sometimes I'll hold them in abeyance till trial to see, did you comply or how many times did we come back? I was told by my colleagues that typically a lot of times attorney's fees are not awarded, which was news to me, but I have been awarding them, and I'm told I can do what I want to do. So
I'll add to that if I can. I haven't seen an increase. I've had them sporadically through the years. I have one pending right now that was presented to me on Wednesday, and it's under advisement. And what I will note is it is not the attorneys doing that the request for fees is made. It tends to be their client's fault. The case I have is a probate matter where it's a guardianship, and the petitioner came in and filed and did not notify grandmother in Texas who had physical custody of the child. The child was up here visiting for the summer, but the uncle came in and petitioned to have the guardianship put in place, notified everybody but mom down in Texas, right? The attorney didn't know that, who was representing the filer. But there's been a request that the fees be assessed against his client. So of course the attorney's in there doing everything he can to argue against that, made great arguments. He said, well, you know, blah, blah, blah. But that's under advisement. But the basic answer to the question is, I have not seen an increase, but my assessment is that it's generally not the attorney's fault that there are requests for fees. It tends to be the client's fault. And frequently the attorneys are caught off guard by what's happened.